a group of mixed other issues that we can take up. So the first thing on that list was the uncontested proposed conditions. Those are, many of them are things that are required by statute or by rule already or by some federal requirement, and Dakota Access has agreed to those conditions. They are, but some of the parties have raised concerns that Dakota Access may not have provided sufficient information about how it's going to comply with those proposed conditions. And what I would suggest in that respect, if the board decides to issue the permit here, that it would be conditioned upon Dakota Access filing regular reports about its progress on complying with those agreed upon conditions, and that it, to the extent any party feels that Dakota Access is not complying with those agreed upon conditions, that they would be able to either notify the county inspector if it seems to be something within the county inspector's purview, or they could file an appropriate motion with the board for the board to take action.
Would that include requiring that the Utilities Board, have the names and telephone numbers for any county inspector that's been hired by any Board of Supervisors?
It certainly could.
I have a question on that as well. When you said notify either the county inspector if it's under their purview or the IUB, would it need to be specified in an order what falls under whose jurisdiction?
I think it'd be better to let the party who thinks the condition is not being met make that decision based on the facts and circumstances at that time. Some things may be appropriate to raise with the county inspector on the spot, who has the ability to declare a temporary halt to construction activities while something gets sorted out. Other things may be more appropriately brought back to the board for consideration and action at that time.
How would a landowner know which avenue to take?
If I were a landowner, I'd start with the county inspector.
So is that information set out then in the ag mitigation plan?
There is the information about what the county inspector can do, and their ability to enforce the ag mitigation plan is set out in there.
Well, I don't think it's in there currently, so are you proposing that be a condition that be added to it?
If it's not in there currently, then it can be added. It should be added to it.
Okay. But that is in our rules, correct?
That an explanation that the landowners can contact the county or inspector with any concerns they might have. I think it's in the rules, it's in the statute, and we handed out to them at the public informational meetings that started this whole process off, but I don't think it hurts to have them get it again as it gets farther into the process. If we're ready to move on to the environmental issues, the most convenient place to find these has been on in the rebuttal or reply testimony of witness Howard, where she laid out a table of Consumer Advocate's proposed environmental conditions, the references for where that's at. I think you have that. It would be should be identified as Exhibit MH reply. Yeah, that's it. And if you'll scroll down, the first of these contested conditions is number 4, proposed condition number 4. which is a recommendation that the Dakota Access should obtain any necessary permits for take of or impacts on listed species or environmentally protected species. Dakota Access has responded that it is not seeking an incidental take permit because the project is not expected to take any federal or state protected species.
David, I have a question on permits like this where at first go through Dakota Access indicates it's not needed. If they were to find that that kind of permit would be needed once they got into the project, if the project was approved, would there need to be some sort of language indicating that any new permit requirements that come up during construction must be obtained, or how does that work?
It's going to be a federal permit, I believe, in most cases, so there would be federal law already requiring that the company obtain that permit if it becomes necessary to have one. So it's, we could have assuming a permit is granted, we could have a general statement in the order that Dakota Access is expected to comply with all applicable federal and state laws, but I think that's expected whether we say it or not. If we're ready, I'll move on to proposed condition number 7. Is the next contested one. And this was a proposal by the Office of Consumer Advocate that Dakota Access should conduct a migratory bird assessment, mitigation, and compliance plan. Dakota Access has responded that that's really something for the United States Fish and Wildlife Service to enforce rather than the Iowa Utilities Board. And that they believe that it's not required for this project under the existing circumstances. The next proposed condition that's contested is number 21. The weed management plan. This is a recommendation from the Office of Consumer Advocate witness to the effect that Dakota Access should prepare a plan and identify cleaning stations to be used on equipment that may be used in an area that has noxious plant species or weeds in order to clean that off the equipment before it moves on. Dakota Access says that its biological field surveys have already determined that there are no large plots of weed infestation that require this kind of mitigation, and standard restoration and revegetation practices appear to be sufficiently protective of the listed habitats.
I have a question on that.
Okay.
I just think of seeds that might be, so let's say they're dandelions and the seeds are dropped by birds or other animals, and then weeds become an issue. Is that something that can later be addressed through some sort of plan? Or
if there were actual damages associated with that in terms of having to put down another treatment of some kind, then that is something that the landowner would be able to take up with Dakota Access. It might be difficult to establish where the seeds came from, but if they're on the right-of-way, it's a starting point. The next contested condition is number 27, relating to the winter construction plan. The Office of Consumer Advocate witness Flo testified that Dakota Access should be required to develop plans for construction activities during frozen conditions. Dakota Access does not currently have such a plan, and it is the company's intention to complete the construction prior to winter arriving. And so they say there's no point in preparing this plan. They have indicated that if winter construction becomes necessary, plans will be prepared and implemented. And in the reply brief, Dakota Access has represented that it will know by July whether it's going to need to have a winter construction plan, and if it does, it will prepare one and file it with the board.
And I know that you're sick of me talking about the bats, but I don't understand how you can decide that you're not going to have winter construction, or even the wet conditions construction, when we've already been told that there are some of these areas that have roosting trees, and the only way that you can remove a tree that is a roosting tree for bats is in winter. I mean, it's cyclical. So how does that happen?
Well, that is a question the board's going to have to consider. That's
well, I've considered that one.
Oh, okay.
I mean, you can't do it. So you have to have a winter construction plan, or you have to have something in the plan that says this is what you do for those roosting trees or other environmental issues that have been raised. Is that correct?
So yes, so that would argue in favor of directing Dakota Access to prepare a winter construction plan at this time. If it appears that the protection of those roosting trees for bats will require winter construction, then they might as well go ahead and prepare the plan.
Sure, Hughes. Well, I think looking at testimony, the only evidence we have is that there may be roosting trees. It's not definitive that there are, and in the species review of the route, there's nothing definitive about those trees.
Do you have any form of testimony or documentation on an environmental study or anything else that sets out that there aren't?
Dakota Access.
Yes, I do.
Board Member Wagner, I was directing it to Mr. Lynch, but if you want to answer, that's perfectly fine.
No, I was just going to add that there was testimony from both, I think, the OCA's witness and Dakota Access's witnesses.
Chair, the Dakota Access stated that it, during its field surveys, it noted the possibility of forested areas and potential bat habitat, and tried to avoid bat habitat in its routing process, which in fact may have caused some of the corner clips that we've seen on some of the parcels. Because it was used as an avoidance criteria, Dakota Access's estimate is that the impacted forested area is less than 5% of the route.
And as I looked through the OCA exhibit for Tom's, where Mr. Thomas indicated two species of bats, he did note that there would be suitable summer roosting habitat for both the Indiana bat and the northern long-eared bat. So if they'd be there in the summer, then I would assume that would mean that they'd be roosting in those trees in the summer, to Chair Huser's concern. It's on page 6 and 7 of Mr. Tom's direct testimony.
Moving on, if the board decides to grant a permit, then the consumer advocate has proposed condition number 13 relating to hydrostatic testing water services. Sorry, I went out of order. That's And what Consumer Advocate has proposed here is that water bodies that have the potential to contain listed or protected species should not be used as sources of water for hydrostatic test water. That is the water that Dakota Access would use to test the pipeline's ability to withstand the operating pressures it's being designed for. Dakota Access disagrees that it has to avoid those sources, saying that it can use best management practices, or BMPs, such as using filters or taking water from the surface of the water body rather than the bottom, if it's an area where a sensitive species may live. Consumer Advocate, in its initial brief, has agreed that the precautions proposed by Dakota Access would reduce the risk, but has argued that the better approach is to take water for testing from sources that do not contain protected species in the first place. The next contested condition is number 30, spoil storage from streams. Number 30, please. Oh, I'm sorry. I thought I'd misspoken. Proposed condition number 30, which should be up on the screen shortly, is a recommendation from the Consumer Advocate that material that is excavated from streams should be set farther back from the stream, farther than the ordinary high water mark, and that the edge of the workspace in those areas should be placed 50 feet back from the ordinary high water mark. They also suggest that the storage area should be in an area with little slope that is less than a 5% slope. These are FERC requirements that apply to some natural gas pipeline construction activities. Strictly speaking, Dakota Access says they do not apply to the construction of hazardous liquid pipelines, and Dakota Access proposes instead that each individual situation should be evaluated and the setback established based on the prevailing conditions.
And on this one, I don't have a problem with that evaluation. But if we were to approve the permit, I would want to know that stipulation that it's assessed is done with the knowledge of the landowner and with the knowledge of the county inspector or the inspector that's been hired. So I understand on this one what they're arguing. But I think it falls back on the ag mitigation plan again, and that landowner know when they're going to be on the property, what's going to be occurring, if there's adjustments based on information that they find in that evaluation or assessment, that all of that information be provided to the landowner.
So the proposed condition would require consultation with the landowner and the county inspector for these stream crossings.
Right, but I would be more, I'd be more generic in the ag mitigation plan, that's the standard that's applied to all of those things that occur when construction is happening on that landowner property. So I wouldn't identify each of them individually.
Okay.
I think that would be difficult for us to control, or
difficult for us to even be sure we identified
right.
everything. So I think that makes sense.
If we just make a general statement that it's our expectation that the landowner and that there is a notice time before construction begins. I don't remember where that was at either.
It's coming up farther.
Yeah. Okay.
We'll get back to that one. The next one would be proposed condition number 36. And this is an OCA suggestion or recommendation that for each water body crossing, the company should identify a proposed and an alternative method of crossing for all jurisdictional water bodies in advance so that the environmental inspector can make informed recommendations to minimize impacts. Dakota Access has suggested that the identified water bodies will be the subject of the horizontal directional drilling, and for the other water bodies, again, they suggest that the best practice is to make that determination at the time and based upon the circumstances that they find when they get there. I'm assuming this one would also come under that consultation.
Right, I'm not disputing the fact that you need to make those decisions when you're actually there looking, but I think that this is also about informing Iowans of what's going to be happening on the property, whether it's DNR or a private landowner.
Dakota Access has already specified which water crossings will be horizontally drilled, right?
That's correct.
And the others, to me, are, as you approach them, how are you going to do them? Because I think even certain water crossings probably have different conditions throughout the year, depending on when you reach them. So in one time period, you might want to do one type of crossing, but if you're going to do it later in the year when there's less water or different conditions, you would probably do a different crossing. So I'm favorable to leaving it up to the construction and letting the county inspectors and landowners decide, or at least have, do the process that they have already.
The last two proposed conditions I had under this section, the one relates to the water crossings, which we've just discussed, and the other one was returning to the winter construction plan, and we've already discussed that, so I'll bypass those. The next group of proposed conditions come primarily from the Northwest Iowa Landowners Association, or NILA, and relate to proposed changes to the Agricultural Impact Mitigation Plan. And the first of these proposed conditions is that NILA proposes, let me back up, the Agricultural Impact Mitigation Plan that Dakota Access has filed with the board is based on the board's rules at 199 Iowa Administrative Code Chapter 9, which specify certain impact mitigation measures that are required. NILA suggests and proposes more stringent standards for the AIMP in some areas and proposes to add language to the AIMP clarifying that the board's Chapter 9 applies only to those areas where the mitigation plan is silent. Dakota Access argues that if the mitigation plan complies with the board's rules, then the board is without authority to create new rules in this proceeding and cannot create more stringent standards. They say that imposing any additional conditions at this time would deprive Dakota Access and potentially other future pipelines of fair notice of what the law requires.
Was there actual testimony on replacing some of those, the language, so the replacement of the 9-month construction period with just a generic sentence? Was there testimony on that? I don't recall that, and I
don't recall that specifically, but there was some testimony about the provisions in the agricultural impact mitigation plan itself, and it's very likely that if not directly addressed, I know there was testimony about the length of the plan itself and how long it should be in effect.
I will add on this point, it is primarily a legal question, and so we have discussed it, and your staff is of the opinion that the board does have the authority to impose more stringent conditions than Chapter 9 would allow or would require. The statute, Section 479B9, is very clear that the board can impose such terms and conditions on a permit if it decides to grant a permit, as the board determines to be just and proper. If the evidence in this case supports a condition that isn't in Chapter 9, then we believe the board has that authority.
I agree with putting in provisions for notices to the landowners. I didn't like the responses at the hearing where, well, when we're ready, we're going to go, and that might be 24, it may be 48. I think that they need to know, okay, construction is going to happen during this window, and it needs to be a period of time that they can actually be aware of when it's going to start.
I would concur on that. I think the more notice that can be given to landowners, the better. And I remember writing notes to myself in margins of notes that the 24-hour notice just didn't seem like that gave much time. If a landowner was out of town or something, that seemed rather tight time frame. Understanding everything's would be pretty, if in that case things would be pretty flexible, because it depends on weather and how much progress or lack thereof they might make if the pipeline was to be constructed.
And you're talking about notice not only to the landowner but to the county inspector. So I mean, there's really two
Correct.
people who really, at least according to the evidence, and that should be notified as construction is being reaching a certain county. Is that?
Yes, in my mind.
I recollect.
Those
Go ahead, Nick.
So those requirements currently are different time frames, correct? The inspector, if I remember, is 14 days, and the landowner is 24 hours. Is that correct?
That's what I think is in the AIMP.
And I would agree that the landowners, I think, need a little more notice than 24 hours as well, and would also offer that it should perhaps be a window of time, and not that we will be doing construction on this day at this time, but I think given conditions they need to have, or changing conditions in weather or just construction schedule, there needs to be some flexibility there to say that it's going to occur between some window or begin at some window.
And yes, both the county supervisors and their hired contractor and landowner, they all need to. What is that notice called? It's not just constructive, it's actual. So it's actual notice provided to both.
And if the board were to decide that that's a condition that they want to place on it, it may be something that the board maybe want to be more specific in the order, because there's a statutory provision that indicates the board shall instruct the inspectors appointed by the Board of Supervisors regarding the content of the statutes and the rules, and the inspector's responsibility to require construction conforming with the standards provided by this chapter. And so there may be some responsibility on the board itself to make sure that the county inspectors have copies of the order if there are conditions in the order that the board's beliefs should be followed.
Susan, I agree with that, and actually wrote that down this morning, that if the board does approve the permit and does place conditions on the permit, those conditions should also be provided to the county inspectors so that they're aware that those also exist.
Would it also be prudent to provide it to each of the county boards of supervisors?
Correct. I mean, I think we would, right, the contact should probably be with both.
Right.
My understanding is the ag mitigation plan that's developed is provided to the county supervisors and to the inspector, and they're told that if a permit is issued, they have to follow this criteria, and that's where conditions and exceptions would also fall. Is that a correct understanding?
I think that's a correct understanding, but I guess I was just emphasizing that the board, if the board decides that there are additional conditions, that they may want to include in the order that requirement to make sure that they're satisfied that the inspectors and the county board of supervisors have that information.
Okay, I'm going to go back again to the ag mitigation plan. We have an ag mitigation plan that's been provided to us. We've had testimony of changes, recommendations that are coming back. If a permit, for permits that have been issued in the past, is the ag mitigation plan, if there are additional changes or conditions as requirements of an order, is that ag mitigation plan included as an attachment to the order with that criteria set out? Or do you direct the petitioner to prepare it pursuant to the order and provide that back to us? How does it work? Which way?
I can't recall that we've actually done it, but the second would be my recommendation, that you require the petitioner to prepare the revised mitigation plan and submit it to the board for review. The next proposed change to the mitigation plan is not really a contested one, as far as I know. NYLA has proposed that the current plan identifies Dakota Access as the author. NYLA believes the language should be revised to state that the mitigation plan has been adopted by the board, so that landowners will know that it is a document, it's the version of the document that the board has reviewed and approved.
So then once again, then that approval would come at the point it's been submitted, then we would authorize it back.
Correct. We would confirm to the company that it has done what we directed, or tell them where they need to fix it.
And when that's filed, then do parties get a chance to make additional comments where they don't think that it complies?
There would be an opportunity for that, yes.
You do it in additional like scheduling order, or this needs to be back to us by such and such date, and they have to respond by.
We would set a short time frame for the parties to review it and comment.
Obviously, I'm learning to be more clear on asking how that works after the fact. Okay, all right.
And that review would only be to items which were directed in the order, and not a total brand new review of the mitigation.
Only to confirm that the changes that were made reflect the board's order, not to re-argue the issues
Right.
that the board may have decided otherwise. That's what
That might
reconsideration
need
or rehearing is for.
Clarified, yeah. Yes.
So, the next proposed condition or change to the mitigation plan is contested. NYLA proposes to add language which it describes as clarifying the roles of the County Board of Supervisors and the County Inspector, and to add a new paragraph explaining the enforcement provisions of the board's rules. Dakota Access argues that the language NYLA is proposing would give county inspectors an unqualified authority to stop the work at any time, and in particular would allow them to stop the company from backfilling a trench if winter conditions appeared to be likely to occur. Dakota Access says this would be unworkable and would exceed the authority specified in the Iowa Code which only authorizes the county inspectors to temporarily suspend work on the project until the inspector is able to consult with the supervisory personnel of the pipeline company.
Legally, because I would come from a county government, construction happens all the time. You have these individuals that have been designated by the utilities board from the county supervisors who have hired them to make sure the construction occurs as set out by the petition or permit or other document. Why would they not have that authority?
I'm in agreement with you on that. Is that?
That'll make it easier.
I was trying to put more words in there. But.
Well, I have a question, because to me this looks like this goes beyond what the current law is, which does allow for a temporary stoppage, and this would create a stoppage for as long as they want it to be stopped. Am I reading that incorrectly?
I think that what it comes down to is the question of what does temporary mean. Is it any stoppage presumably only lasts as long as it takes to correct whatever situation or to understand whatever situation there is that has been encountered, and then work is going to proceed again. So I don't see it as an open-ended forever stop the project provision.
But does this change, or this is what I would consider a significant change to the past procedures and rules of the board, in that you are changing the authority of the county inspector without going through a rules process or anything to determine whether or not, and there's no evidence in the record that shows that the current process that we have in our current rules with county inspectors is flawed and does not work correctly. And
certainly that is Dakota Access's position as to what has been proposed. I'm not sure that staff agrees with that interpretation of the NYLA proposal. We think that NYLA's proposal contemplates the temporary work stoppage in section 479B20, and it's really not inconsistent with that statute.
And the other item is that when you look at the statute, you have to read the other provisions which allow the county board of supervisors to file with the board if they think the construction has not been in compliance. So read together, I'm not sure exactly how that would work, but it appears you have to read those provisions together to determine exactly, as Mr. Lane said, what temporary means.
And so when you talk about provisions, are you saying that our current provisions allow for the board of supervisors to file with the board?
Right, that's in the statute. It's in the statute.
Okay. All right. So that NYLA, from that perspective, NYLA hasn't proposed anything new.
Right. I think NYLA has proposed to use different words than what's in the statute, and that may be where part of the problem lies, that it's not simply repeating what is the statutory language, but they've tried to state it in what they believe to be a clearer manner, and there's some dispute over whether that's clearer or has changed the meaning.
So potentially, as I'm looking at the language that NYLA proposed, maybe it's some addition to the ag mitigation plan that is kind of in between here, but more focused on what's actually in the code, just stating that for clarification. It appears that may be partly what NYLA was trying to do here, and making sure that that is just part of the introduction and the ag mitigation plan.
I think that's
correct.
correct.
That may yet be another interpretation.
The next proposed change to the mitigation plan is a proposal to delete language stating that the mitigation measures will be implemented only if they do not conflict with federal, state, and local permits, approvals, and regulations. NYLA argues that the county inspectors should not be given or burdened with the task of interpreting federal, state, or local laws or other provisions while in the field. Dakota Access has not specifically responded to that proposal as far as we can find. The next proposed change involves a notice.
Well, Dave, can we, on that real quick? I'm confused as to how logistically that would work. So if there was something in the mitigation plan that did conflict with a federal law or permit or approval or regulation,
then the federal law would control. Or Dakota Access would need to find a way to comply with both of them.
So on one hand we have, sorry, are you done, Mr. Wagner?
Yeah, go ahead.
So on one hand we have the idea that the county inspector shouldn't be burdened with determining whether or not there should be a temporary stoppage. But on the other hand, we want them to identify what the federal laws are related to all of these mitigation issues. Am I interpreting that?
I think that's kind of where Dakota Access is, and NYLA's on the opposite side of it, wanting to give the county inspector, recognize the county inspector's authority to stop the project, but not requiring that the county inspector be familiar with all applicable federal and state permits requirements.
Okay.
So as I was saying, the next proposed change to the mitigation plan would be a requirement that the company give 4 weeks notice to the county boards of supervisors prior to the beginning of construction, so that the county would have adequate time to arrange for the on-site inspectors to be out on site. NYLA also proposes to delete language in this section that indicates that pipeline will take approximately 9 months to complete, because NYLA believes that winter construction is likely to be required.
What is the significance of having any time frame in the ag mitigation plan?
Well, in terms of this specific time frame, I believe the record contains evidence that at least 16 of the 18 counties have already made arrangements for their county inspectors. Is that correct?
I think that's what, at least I think the evidence is.
So if the purpose of this 4-week notice is to allow the county board of supervisors time to make arrangements for those inspectors, to hire inspectors, then it seems unnecessary in most cases. If it's only a 4-week notice to be sure that the inspectors are actually available and have cleared their calendars for the appropriate time frame, then it may be an appropriate requirement. We don't really have that kind of detailed information about why it's been proposed.
Yeah, and I guess I should have been more specific. I was referring to the construction time frame in the NYLA proposal to delete language indicating the pipeline will take approximately 9 months. Is there any significance? What happens if 9 months, it says they're going to take 9 months and they take 12?
Probably in that instance, nothing. The language that was in the plan was more informative than restrictive. It was simply to let people know that the plan was to get it done in 9 months, but we all know that plans and timeframes don't always hold.
I was always of the understanding that that's more about, hey, we're going to be done because we're not going to be on your property, and I want to know when they're going to be off my property. So that's where I thought that 9 months was coming in. That's why I thought it was part of it, to allow the landowners to know if we're not done in this time period, we don't have authority to come back on that property unless we get something. But so maybe my interpretation was incorrect of that particular time period. And then on the other piece, I don't have a problem with whichever direction we go. But again, my understanding is the county inspector has been hired in most cases specifically for this project. In fact, like 10 of them already or 9 of them already have somebody hired. If they have an individual hired, the issue is making sure that the inspector is notified of when the construction is expected to occur, and they're able to make sure that the landowner knows and the inspector can be out there when they're performing the construction. So whatever the time period is.
I think that's correct, and the only evidence we really have of that time period that I'm aware of is this 4-week proposal from Northwest Iowa Landowners Association.
But doesn't that go back to our discussion about notification of construction activities to both the county inspector and landowner that we talked about earlier today?
Yes.
I think we need to make sure that we're synchronizing all of these dates. And I think somewhere having a timeline would probably be helpful down the road as we continue to look at this as to what time. So we're not developing time frames that are in conflict with each other. I guess that's the best way.
And that's why I asked about the ag mitigation plan, because all of these different things can be set out in that document so you can see it in one place. And some of them are.
Yeah, I guess my point was that both this time period and the previous notification time period we talked about are the same thing. They should be the same thing, and they're repetitive.
I think that if the board does grant the permit, then once we know what all these notice concerns are, we'll be able to consolidate them in a meaningful, efficient manner. The next proposed change to the mitigation plan involves points of contact. Dakota Access proposes to designate a statewide point of contact for landowners, that is a mailing address and telephone number, that will be available until at least 1 year after completion of construction, and also to provide landowners with contact information for their local representatives, what Dakota Access calls the geographic area representative, at least 2 weeks prior to construction. NILA proposes that the statewide point of contact should be maintained longer than 1 year after construction is complete, and that at least 3 weeks written notice to the landowner should be provided regarding the local contacts. Finally, NILA also proposes that each landowner should be permitted to designate their own point of contact for Dakota Access to contact them. And that may go to Board Member Jacobs' concern about what about the landowner that's out of town, goes on vacation or whatever, that they would be able to have an express right to designate where that contact should be made while they are out of town.
It seems to me that having a statewide contact for over a year makes sense, just because there could be issues in terms of the ag mitigation plan being fully implemented. There could be weather delays, some of those things. It seems to me at least the statewide contact needs to be out there longer. And the 2 to 3 week difference, once again, try to sync all these dates up and match them.
The next one's something I think we've already touched upon. NILA proposes that a change to the definition of proper notice to the landowner proposing a language that would allow each landowner to request and receive at least 24 hours written notice before trenching, permanent tile repair, dewatering, or backfilling takes place in any specific location. Dakota Access has objected to this, saying it cannot logistically provide such notice to over 1,200 landowners. I think we've already talked about that one. NYLA's next proposal relates to the definition of qualified technician, a term that's used in the Agricultural Impact Mitigation Plan. NYLA proposes to define the term as including any person who regularly installs drainage tile or soil conservation practices or structures. NYLA alleges that this has been an issue for landowners who have attempted to submit tiling plans or other soil conservation plans to Dakota Access in 2015. And I'm not aware of any company response to this proposal.
David, does this, if we create a definition of qualified technician, does that essentially create an addition to our board rules that should go through a proper stakeholder process to define exactly what that means?
I think this just goes to clarifying the term is already used in the Agricultural Impact Mitigation Plan, and qualified technicians are identified in the plan as people who, what I want to say, can give an opinion on how tiling may be done in the future, or where it could be done, or what provisions might be appropriate in connection with that. So to add some clarity to that phrase may avoid disputes down the line. I don't think it's a substantive change other than to try and clarify exactly who does and doesn't qualify as a qualified technician.
Okay.
The next proposal is a contested one regarding the separation of topsoil and subsoil. NYLA proposes to restate the requirements in Section 6.2 of the Agricultural Impact Mitigation Plan to require that all topsoil, well, let me back up. The current plan requires that Dakota Access will separate out all of the topsoil up to 36 inches deep and stockpile it separately. And NYLA has proposed that that should not be limited to only 36 inches, but that if there's more than 36 inches of topsoil in a particular location, then that should be, all of it should be stockpiled separately. Dakota Access has responded, as we talked earlier, that the 36-inch requirement is in the board's rules at Rule 9.4, and that they believe they cannot be required to do more than the rules require.
I do have a question on that. I don't recall any of the other witnesses indicating this was necessary, the OCA's witnesses? But
Not that I'm
also
aware
wondering,
of.
I'm trying to recall a conversation with Mr. Mahmood, if he indicated this was something they were considering. Looking through my notes.
There was some testimony from someone for Dakota Access, and I'm sorry I can't remember the name, to the effect that in most of Iowa, the topsoil depth runs approximately 15 to 16 inches, and therefore the likelihood of seeing more than 36 inches of topsoil in a particular location is small. To me, that cuts both ways. It on the one hand maybe says you don't need to extend it below 36, but on the other hand means that if you did say all topsoil, it's not going to happen very often.
So the operative word there would be all topsoil instead of the actual.
And I think the real focus there is, even if you have one landowner who does have topsoil over 36 inches, the question for the board is, should that be taken into account, or should you set a limit on the removal of topsoil?
The next proposed change to the mitigation plan relates to above-ground facilities, and we're going to address those in greater detail in connection with the condemnation easement. So I'm going to move past that one at this time, and we'll take it up again in a few minutes. And that leads to the next contested proposal. It relates to dewatering standards. When does water get pumped out of a trench? NYLA proposes language requiring that any open trench should be pumped out when the water level is 9 inches deep or deeper. The original mitigation plan language did not contain a set standard for when dewatering would be necessary. NYLA also proposes additional language requiring the approval of the county inspector before dewatering may take place, and prohibiting pumping water outside of the easement areas without the landowner's permission. That last one I think we've talked about in connection with giving the landowners notice and requiring that they be consulted with in connection with the construction activities. Dakota Access argues that what it's proposed in its mitigation plan complies with Rule 9.4 sub 10 of the board's rules, and that it, sorry, I skipped over a step in here. Sierra Club has also proposed in this connection that the mitigation plan prohibits construction when the field conditions are too wet, and Sierra Club has proposed defining that wet soil conditions as situations when field moisture conditions are not suitable for normal farming activities. And OCA has stated it has no objection to that change. Dakota Access argues that under the existing Rule 9.4 sub 10, those wet soil conditions have been defined as times or locations where the passage of heavy construction equipment may cause rutting to the extent that the topsoil and subsoil are mixed, or where underground drainage structures may be damaged. And that's the language that Dakota Access has included in the mitigation plan. Dakota Access argues that the proposed Sierra Club test, that it should be when the land is not suitable for normal farming activities, is subjective, that the test existing in the board's rules is easier to apply and has already been interpreted in the field many times for other projects, such that there's an effective standard in place.
And to the best of my recollection, there wasn't any testimony that came up with that magic number, 9 inches, to be in the open trench. I don't recall it anywhere, but
I don't recall any testimony supporting any particular figure. I think NYLA's real point is that there should be a defined number where dewatering has to take place. That brings us to the end of the mitigation plan proposals and up to the condemnation easement issues. Dakota Access has filed with the board a proposed easement that it would like to use for any condemnation proceedings that may be necessary if the board grants a permit and if the board grants the power of eminent domain. One of the terms that the parties have objected to in that proposed easement is a term that would give Dakota Access the right to place above ground appurtenances, primarily valves, on any of the condemnation parcels at any time in the future without having to acquire any additional easement rights at that time. The testimony in the case establishes that Dakota Access is only planning to install valves at 66 locations, valves or other above ground equipment. Each of those is already the subject of a separate easement. So and Dakota Access's witnesses have testified that the company does not currently need valves in the other condemnation parcels. Dakota Access argues, however, that if it is allowed the language in the condemnation easement that it has proposed, then if in the event of changed human or environmental conditions in the future that it required to install additional valve sites, then the language would enable the installation of additional valves without subjecting landowners to another condemnation proceeding. And Dakota Access does state that if this were to occur, it would provide additional compensation to the landowner. The consumer advocate has argued that future above-ground appurtenances should be the subject of new negotiations regarding location and compensation between Dakota Access and the individual landowners involved. Future changes should be addressed only when those changes are known.
So, Mr. Lynch, when we go back to talking about the easement agreements, or whether it's temporary construction, it's part of a taking that occurs, where normally does the Iowa Utilities Board place the language related to the type of access that the company would get to a parcel?
That would typically go in the easement documents. There would be separate easement descriptions for the permanent easement and for the temporary construction easement, and both of those could contain language relating to how the company is going to be permitted to access its property, its easement.
But when do we get that information from them? I mean, they testified that they weren't setting out exactly what it was and that it was non-specific. That's in the briefs. That it wasn't. When exactly do we usually require that information?
Well, if you if you were to grant eminent domain and you allow them to use the easement that they proposed, you wouldn't get that information because they'd have the easement to cross it where necessary for construction.
But the information we have set that from the testimony from Mr. Fry was that they're attempting to find various different types of easements, but they admit that they're attempting to obtain them non-specifically, such as the access easement. So they're not. They don't have a legal description for it. They aren't saying here's where it is. They're saying we get access.
Right, and if you adopt the language that's in the easement that's been filed, then they would have the right to have access as needed for construction and for repair and maintenance.
Okay, I understand that. So where do they have the right to access the property? Are you saying everywhere that the easement is at any time?
If that's what the easement says, I mean that's the whole issue.
Well, the problem is the testimony that they've given to us shows that they didn't provide that.
Right, and the landowners have said, no, you need to go back and
give that to it. Tell us where you want to access.
Tell us where it is, or describe specifically where you're going to cross the property. And if you remember when we talked the specific parcels, there were some that said, and I think Ms. Murray is probably the best example. She said, there's a road, I don't remember the exact highway, but they could access from that road rather than having access to the entire property to cross. And there's other evidence of that, that it has suggested, well, they really only need to be able to access along the easement itself, and maybe they shouldn't have additional access unless there's some reason for it. So, I mean, that's really the issue I think that's being presented is, and especially by Mr. Murray and Nyla, is what kind of limitations do you put on that access easement?
So then our order would say, you didn't ask for any access, so we're not going to, you didn't give us any specific access point, so you have to come back to us where that is, or we're going to say, since you didn't request it, we're not granting that.
I think that's the decision the board will have to address as we go, and I think as we go parcel to parcel and talk about, and then we talk about the easements based upon those decisions.
Now, we do have testimony from Dakota Access witness Johnson to the effect that unless there is a specific access easement that has been defined and requested, or unless the landowner agrees otherwise, Dakota Access intends to access the easement area along the easement itself. So that would be language that could be put into the easement, that the easement only gives them a right of access along the easement itself unless the landowner agrees otherwise.
But you do have the statutory language that provides in 479B17 that a pipeline company shall have reasonable access to the pipeline for the purpose of constructing, operating, maintaining, or locating pipes. So you do it seems to me that there is a requirement that you may almost have to go parcel by parcel to determine what's reasonable for each parcel.
Or we can just define that reasonable is along the existing easement.
We can say that it's a full taking of the property because they have access at any time.
Not if the easement required that access be provided only along the existing easement.
So you have two issues, Mr. Wagner. One is the temporary construction easement, and one is the access easement after it's constructed. So for
Yeah, but you also have the permanent easement.
Or is there a generic approach that the board could order that each easement agreement will specify in detail the locations of the easements, something along that lines too?
Well, the easements do specify the area that is subject to the easement for the permanent and temporary construction easement. I think the question is, as Mr. Wright pointed out, when the statute requires that they be granted reasonable access to the easement area, in most situations, I think the reality is that reasonable access is access along the easement. When they're constructing, they're going to want to just move down the easement area. And that kind of addresses the temporary construction easement. For the permanent easement, there may be more of a concern regarding maintenance of activities or in the event of an emergency of some kind, that the need to access however they can. And the statute does contain provisions that would allow them to do that and pay the damages that they cause in accessing across areas that they don't have that easement right.
And it may not be reasonable for all parcels to use the 50-foot wide easement to access it, depending on what's located at the edge of the property owner's property. You have hills and trees, and so it may not be a reasonable for them to access it from that location.
So where I would be on the easements is I think that it needs to be clearly defined as it's set out by statutes, and it cannot be generic. It has to be specific in nature as it relates to each type of easement and what we're granting for access easement. And I think that the language that's currently there is overbroad.
agree with respect to the access easement portion. And did we skip over the above ground items?
We skipped over it earlier, but we did discuss the, at least I thought I addressed them, the provision that Dakota Access is saying that in the event that they want the right to put valves on any parcel, any condemnation parcel in the future, in the event that changed human or environmental conditions warrant additional or changed valve sites. And Dakota Access says the benefit of this is that it would enable the installation of additional valves without subjecting landowners to another condemnation proceeding. And that's where the consumer advocate has argued that any future above-ground appurtenances should be the subject of future negotiations regarding location and compensation between Dakota Access and the individual landowners that are involved.
And this is where we've had the conversation about the landowners who have voluntarily entered into the agreements and those that would be subject to, should a petition be granted, eminent domain, that we don't believe we have any right to change those private contracts that have been entered into voluntarily by landowners, correct?
That's correct.
Therefore, the only change would be that we would remove the language that that's part of this easement and this eminent domain process. And I would be in favor of removing that.
That's correct.
I'd also.
I would as well. Oh, sorry. Go ahead, Board Member Jacobs.
It was me, and never mind.
I would as well.
The one caveat that I would maybe add is if there are locations where there's a likelihood that a valve might be needed, that be indicated somehow by Dakota Access on that particular easement. But otherwise, unless the valve is already in the H file or there's a high likelihood, and they can show why there's a high likelihood they might need it for that parcel, I don't think it should be a part of the generic easement for the eminent domain parcels.
Certainly, if Dakota Access determines that there's a high likelihood that it will need a valve at some location other than the 66 it's identified already, then it can file an amended Exhibit H for the necessary parcels with a specific valve easement.
How does that work if they are either all the way through or partially through the county level condemnation process?
It would depend on exactly where they were in that process. It's possible that they would have to amend their filings or go back and start over, or if they had actually completed it, to commence a new condemnation process if they needed additional rights they did not condemn the first time around.
And would they have to file a new petition with the board, H file, that we would then have to approve?
Usually it would be an amended Exhibit H with the board. It happens from time to time when they get out there in the field in the project, not so much with hazardous liquid pipelines. We don't have that many of them, these HLP dockets, but with other linear infrastructure dockets that they get out there and find out something that they didn't anticipate in the field. They need some rights they didn't have, and they file for an amended Exhibit H, and the board acts on it. And Exhibit E in transmission lines. The next proposed change to the condemnation easement relates to language that's included in the proposed easement form, where Dakota Access seeks the right to reconstruct, realign, or relocate the proposed pipeline to any location within the 50-foot pipeline easement area without having to acquire further easement rights. NILA describes it proposes to eliminate those words, describing them as an unnecessary overreach.
David, I have a question. How does that align with the 600-foot rule?
I think it is contemplated in the permanent easement that as the pipeline is being constructed, it may be located realistically just about anywhere within that 50-foot easement based upon the real geographic conditions that the company encounters as it's building the pipeline. I don't think it can move outside that 50-foot easement area without acquiring additional easement rights, and that's where the 660-foot rule doesn't really deal with easement rights, but is addressed to when do they have to come back to the board for an amended permit. The next proposed change to the condemnation easements relates to the temporary construction easement. Dakota Access has proposed that the temporary construction easement should have a term of 18 months. The Northwest Iowa Landowners Association believes that installation of the pipeline should be performed in a manner that may require more time than that, and so NILA has actually proposed to extend the life of the temporary construction easement to either 2 years or 30 months.
So, and this goes back to the previous conversation we had about the 9-month time period, and then this being the 24-month time period. How did those all mesh together? I mean, what's the point? There had to have been a point.
Well, if there is a specific point to those numbers, it would be something Dakota Access didn't share with us. My speculation would be that the 9 months is what they hope to accomplish. They hope to have it built in 9 months. The 18 months that they proposed in the temporary construction permit was doubling that figure, basically to give them some slack in case the weather was bad, they needed more time. The 24 or 30 months that NILA has proposed is simply longer than that.
But back to winter construction, wet conditions, none of those things being in the plan, that wouldn't seem to fall in line with 9 months or 18 months.
And I can only assume that Dakota Access, as they said, they expect to commence and complete construction before winter weather sets in.
So once again, I think this number hinges on that whole timeline that we talked about, and whether it's 18 months is appropriate or 2 years or whatever. And I think we'll see that play out a little better when we try to put together a timeline.
And I would assume that if the construction takes more than 18 months and they have an easement of 18 months, they would have to go back and receive a new easement.
Right, they would need to, or at least they would need to negotiate that with the landowner at that time to have additional, the right to be on that property engaged in construction activities beyond the 18-month period.
So it seems to me a shorter time period would be more protective of a landowner than a longer time period.
That would be one way to look at it. The next proposed change to the condemnation easements involves fences and gates. Dakota Access's proposed easement form includes a term that requires that if a landowner or party in possession of the property erects a fence across the easement, then the owner must install a gate in the fence and supply Dakota Access with a key. Dakota Access also must be permitted to install its own lock if it so chooses. The Northwest Iowa Landowners Association takes issue with these proposals and instead proposes that if a fence is in existence prior to the existence of the pipeline easement, then Dakota Access should pay for the gate. And if the fence is installed after the pipeline easement is in place, then the owner must pay for the gate, whichever one is responsible for installing the gate would be responsible for supplying the other party with a key to unlock it, and that both parties would be allowed to install their own locks if they chose, but the method of locking would have to be such that either party could open the gate without the assistance of the other.
I'm not speaking for all the board members, but for those of us that have experienced fence line disputes, township trustees, and all those types of things, put the language in there so that it's set up so that the key gets provided to both parties. Whoever puts the lock on has to give it to the other one, and the gate has to be repaired by whoever damages it. That's probably one of the more simpler provisions, and we're following, I think, the law as it relates to fence line disputes and who's responsible.
And that certainly sounded like the voice of experience on the...
There are times.
I fully agree.
The next proposed change to the condemnation easement, Dakota Access's proposed easement would give the company the right to review and approve the landowner's plans to do any of the following within the easement area or in any location that could adversely affect the easement area. And then those activities would be construct or install any temporary or permanent site improvements other than streets and roads. Second one, to drill or operate a well. Third one, to remove soil or change the grade or slope. Fourth one, to impound surface water. And the fifth one, to plant trees or landscaping. Northwest Iowa Landowners Association objects that any plan approval rights should be limited to the 50-foot permanent pipeline easement area, and it should be clarified that the approval of Dakota Access shall not be unreasonably withheld. We'll move on. The next one is the right to trim or cut down trees or shrubbery. Dakota Access seeks the right to trim or remove trees and shrubbery that in the sole judgment of Dakota Access may be necessary to prevent possible interference with the easement area. Again, Northwest Iowa Landowners Association proposes that the right should be limited to the actual easement area and should not extend beyond that 50-foot area. Finally, Dakota Access in its condemnation easement proposes that it would have the right to assign its easement rights without limitation. NILA proposes that any assignment of easement rights should be allowed only after the assignment of the permit has been approved by the board pursuant to Iowa Code Chapter 479B. NILA also suggests there should be a notice requirement associated with this to make sure that landowners have the most up-to-date contact information if they need to contact the pipeline company at some point in the future.
Has this issue of assignment of easement come up in other dockets here or after the fact and things that have been approved?
I'm sure we've had pipeline permits that have been transferred from one company to another or one entity to another. I do not recall any disputes regarding the transfer of the easement rights.
And any time a transfer of the pipeline operation permit occurs, that does have to come back to the board for approval. Correct?
I will have to double check, but I think it depends on what the transfer is, because in some instances they only have to give the board notice, and they don't have to have approval.
Okay. I thought I remember reading the rules that, yeah, I guess I don't remember whether it's notice or approval either.
Do you want us to wait while you look that up? Or do you want
I can look it up real quick if you want.
It's up to you. It's your call.
Okay, just to be specific, what the rule at 199 IAC 13.19 says, no permit shall be sold without prior written approval of the board. And then a petition for approval shall be jointly filed by the buyer and seller, and shall include assurances that the buyer is authorized to transact business in the state of Iowa, etc. But it does say at 13.19.2 that no transfer of the pipeline permit prior to completion of the pipeline construction will be effective until the person to whom the permit was issued files notice with the board of the transfer. So I think it looks to me that the rule makes a distinction between a transfer while construction is occurring and the sale of the pipeline itself after construction is completed.
So after completion, the board does have to approve the transfer.
That's the way I'm reading it now, correct.
And if we're done with that one, that brings us to the end of the proposed changes to the condemnation easements. And back to our last category of proposed terms and conditions, the sort of catch-all, which I've organized by party. And we'll start through those. And
So my intent is to give you a 10-minute break and come back in at 2:40. Let Technology Bureau get a break. Have that, and then try and get through the rest of this.
perfect.
Is that all right?
Thank you.
Okay, the Iowa Utilities Board will recess for 10 minutes. Nick, do you want us to call you back? Okay, never mind. You got to hang on.
Okay.
The Iowa Utilities Board is back in session. Mr. Lynch, you may continue.
Thank you. Again, I've grouped this next batch by the party that proposes them. In some cases, multiple parties have proposed a condition, and when that's the case, I will bring it up under the party that seemed to have the most extensive discussion of the proposal. The first one I've got here is the Science and Environmental Health Network proposals. They propose, among other things, that the board should impose a condition that would require removal of the pipeline if it is abandoned. The Dakota Access has suggested that in many cases, landowners, if the pipeline were to be abandoned, in many cases, landowners might prefer not to have their land disrupted again by the removal of the pipeline, and that should be an individual decision. The Iowa Code does give each landowner, if there is an abandoned pipeline, each landowner gets to make the call as to whether they want the pipeline removed or not. The Science and Environmental Health Network also proposes a condition that would revoke the permit for any spill of over 100 barrels of crude oil or other product. I am not aware of any Dakota Access response to that proposal specifically. And finally, the network proposes that the board should withhold the permit until all remaining county, state, and federal permits and authorizations have been issued and have been reviewed by the board. Dakota Access has argued that the board should follow the more normal process of issuing the permit subject to receipt of those other permits and authorizations. The next batch of proposed conditions comes from the Office of Consumer Advocate, and the first one here is that Consumer Advocate proposes that unconditional and irrevocable financial guarantees should be required from the parent companies. OCA argues this condition is consistent with Dakota Access's own evidence and arguments. In its initial brief, the company argued that it makes sense to rely on the assets and guarantees of the parent corporations because their interests in preserving a $4 billion asset and restoring it to service are aligned with the interests of Dakota Access. Dakota Access has offered some parental guarantees into the record, but they are subject to some terms and conditions and to other documents that are not in the record, which makes it impossible to say that they are unconditional or irrevocable. The second Consumer Advocate proposed condition is to require Dakota Access to provide the board with construction plans, even if another agency has specific regulatory authority over those documents, so that the board staff can review them to ensure that any and all conditions imposed by the board are included in those plans. Dakota Access has not specifically responded to that proposal. And finally, the Consumer Advocate has proposed that Dakota Access should be required to implement certain measures it has already committed to, that in addition to the company's commitment on the record, it should be made an express condition of the permit, and that includes things like repairing all tiles damaged during construction, relocating drain tiles, and installing headers along the pipeline in fields where it will cross extensive tiling. Dakota Access says the tile repair provisions are required by law. Consumer Advocate has also proposed that Dakota Access should provide landowners with GPS coordinates for all drain tiles it discovers during construction, and Dakota Access says it is already committed to do so, so that condition would be unnecessary. The next proposed condition comes from the Sierra Club. Sierra Club has proposed that prior to issuing the permit, the board should require an environmental impact statement or the equivalent from Dakota Access, including consultation with the state archaeologist's office. Dakota Access responds that the board has previously rejected Sierra Club's contention that an environmental impact statement or assessment is required or would be meritorious in the board's October 5th, 2015 order in this docket. Dakota Access says it has conducted on-the-ground field surveys of 98.4% of the route and used that information in its routing to avoid environmental resources, and that the Dakota Access asserts that OCA witness flow has agreed that Dakota Access's responses to the environmental recommendations, quote, essentially satisfy my recommendations, end quote. The next set of proposals come from Keith Puntney. He proposes a requirement that the pipeline must be inspected annually, and if it is found to be retired or unused, the removal of the pipeline should be required. Dakota Access notes that there are provisions in the code for abandonment of pipelines or for maintaining a pipeline for future use, and that those statutory provisions also allow for removal of the pipeline if the landowner so wishes, but do not require removal in all circumstances. Mr. Puntney also proposes including a clawback provision in the permit so that any subsequent purchaser of the permit would have to meet all requirements of Chapter 479B except the routing requirements. This would include an opportunity for public comment on the proposed transfer of the permit before the purchase would be permitted.
On that issue specifically, any condition that we place on the issuance of a permit for any pipeline, if it's sold or transferred, don't they have to comply with the original permitting petition?
Well, if it is sold during construction, then they would have to comply with all of the conditions that the board places on with regard to construction. And I think that also goes to if there are conditions on there that are that the board puts on the pipeline that apply after construction is completed, then a purchaser would have to take the pipeline with those conditions. I just don't know that there's very many that actually apply after the construction. But they'd have to take it subject to the easements that have been agreed to or ordered by the board and all of those conditions.
But if I understood your question, you were asking, wouldn't the new permit holder have to meet the requirements of 479B in terms of the types of entities that are eligible to hold a permit?
Correct.
And the answer is yes.
And the financial requirements and any of those types of things, they would have to meet them, correct?
Correct.
So what's being proposed would simply be applying those same conditions or requirements to a new entity. Is it a little more difficult than that?
Correct. The only thing more that would be a change from current practice is the proposal that they would have to go through and hold public informational meetings again.
We're right.
Other than that, it's pretty standard. The next set of proposals comes from Farm Bureau. The first one is that the board should require Dakota Access to pay for all damages resulting from the construction project in accordance with Iowa law. What this really relates to is in some of the documents that Dakota Access has provided, they have specified what crop damages they will pay for a period of 3 years on a declining scale of, I think, 100%, 60%, 80%, 60%. And Farm Bureau is pointing out that Section 479B.29 requires compensation for all losses caused by construction of the pipeline, not just for a short period of time or specified percentages. Similarly, Farm Bureau proposes that Dakota Access should have to compensate landowners for fertilizer, lime, or organic material applied by the landowner to restore the land to full productivity, for the increased cost of installing future tile drainage caused by the existence of the pipeline, to pay for any damages to land or reduction in land values occurring outside the temporary or permanent easement area. Those are all requirements that are in statute, but Farm Bureau believes they should also be made conditions of the permit.
So, David, if those are in Iowa law, does it matter whether or not we condition the permit?
To the extent, let me put it this way, I have a hard time conceiving of a factual circumstance where it makes a difference. the legal requirement is the requirement, and if a county board of supervisors at some points thinks that Dakota Access is failing to comply with what the statute provides, then the statute allows that county board to bring a complaint before the utilities board to get the matter resolved.
To anticipate and make sure that it's clear to all parties, would it not be beneficial to simply add it into that ag mitigation plan as well, in the section that talks about compensable damages after the fact? Cecil looks like Mr. Wright looks like he's going to respond.
Well, I mean, you could do that. The only thing I was going to say, the damage plan is really an attachment to the ag mitigation plan. So, but what you're saying is put those details in the damage plan itself.
Just, if it is the law and it's a restatement, it's simply setting it out so people have a better understanding. I see no harm in that. In fact, I think that it's beneficial.
And just a little levity. The order is going to be rather long the way it is. The more we attach to it, the longer it'll be. and that's just a comment.
Correct. So that's why I was asking. So why wouldn't we just say we got to comply with all Iowa laws?
The one area where I think a more specific statement might have real value is in this, wherever it is, and I've not identified the location, but wherever it is that Dakota Access has specified a schedule of crop damage payments over a 3-year period at fixed percentages, to add there that does not abrogate the provisions of 479B and the requirement that they pay for all the damages that are caused by construction.
You can proceed.
A number of the others here have already been addressed at other times, and really what we're left with is the very last of the possible conditions on the permit. It's not one that any party has specifically proposed, but the issue has been raised. Mr. Puntney and Mr. Lamb and his group have argued that if Dakota Access is granted a permit and if the company is granted the power of eminent domain in this proceeding, the company might reduce its offers for voluntary easements in the expectation that the condemnation process will be expensive for property owners and may result in lower prices for those easements. That concern could be addressed by imposing a condition that Dakota Access must continue to offer to purchase voluntary easements with the same terms and conditions that have already been offered to those landowners for the same prices that have already been offered. In that way, the landowners would then have a choice between going to the Compensation Commission and seeing what the result was there, or taking the voluntary easement. The terms and conditions of the two easements would be different. The voluntary easement may contain terms that would not be allowed in the condemnation easement, but it means that the landowners don't get put in a worse bargaining position by the actions of this agency. We saw a similar proposal from Rock Island Clean Line in that case.
It would seem that would be an appropriate acknowledgement to have.
I will say in my experience, the board's experience, that has been standard practice for utilities and others building linear infrastructure, that they put an offer out there, it's on the table and stays there. That Typically, there is real value to voluntary easements as opposed to condemnation easements because of the additional rights that can be included. So I think best practices for utilities is that they go ahead and do that, and any other entity that's going to construct this kind of infrastructure. And that's the end of the proposed terms and conditions.
Mr. Lynch, Mr. Wright, do you have anything further?
I don't have anything further.
So for those that are watching or are in attendance, it is the board's intent to make a motion to go into closed session. During that closed session, which we anticipate will be for the remainder of the day, it is our intent to look at and to continue to provide deliberation and recommendations to the board or to the staff attorneys with the board's recommendations on pieces of the deliberations so that we can continue to move forward and put together an order that has those areas where we've reached consensus. For this evening, it is our intent also to come back in probably around 4 o'clock. That's when our live streaming stops, and recess until March 9th. On March 9th, it is our intent to come in, have a proposed order that all of the board can review. We will then go into closed session again and attempt to work through any additional issues that we see in that review of the written document. When we come out of the closed session at that time, the board will make statements, and either on March 9th or 10th, it is our intent to have an order that will be presented. Are there any other questions? Otherwise, I'd entertain a motion.
I move that the board move into closed session.
It's been moved for the Iowa Utilities Board to go into closed session. Those in favor of the motion say aye. Aye.
Aye.
Those opposed say no. The motion is carried. The Iowa Utilities Board will go into closed session, and as I stated, we will come back out of closed session around 4 o'clock for live streaming purposes and recess until March 9th.